Taken 41 minutes.
I'll be very brief, my lord. I rise to make only 3 points. In response, my job is to carry Mr. Mwita's books. Yes. I'll be very quick now. In summary, my lord, stripped to its bare essentials, what my learned colleagues for the respondents will be telling you shortly is that this honorable court has no jurisdiction on 3 primary limbs. They will tell you that the doctrine of separation of powers precludes you. They will tell you, secondly, that the dispute before you is not ripe. They will tell you, thirdly, that the matter is sub judice and should therefore not be heard for you. They will cite for you, my lord, an authority listed in the, I believe, grounds of opposition of my good and learned friend, Mr. Kuyoni Josephat, for the Attorney General. This is the case of Mate and another one versus Wambora and another. My lord, that decision is wholly distinguishable from the case before you, because what had happened when my lord interrogates the circumstances, a court order was obtained in the middle of deliberation and debate by the County Assembly of Embu. In contrast, my lord, the matter before you has a ripe resolution which we have attached, my lord, to the petition. These are the words of the Speaker of the Senate, my lord, in that document. This is the resolution. I'm reading directly from the resolution. Whereas on the 8th of October 2024, the National Assembly, having considered the special motion resolved by the support of 282 members, being at least 2/3 of the members of the National Assembly, that pursuant to the provisions of Article 142 as read with Article 151B of the Constitution, the Deputy President of the Republic of Kenya be removed from office by impeachment on the grounds specified in the special motion. In the words of the Speaker, and I also have the words of his advocate present before you here, my lord, the impeachment is complete. Allow me to read the words of my good friend Mr. Milimo. This is the ruling, my lord. We've attached it in the further affidavit before you when they appeared before Justice Mugambi. This is what he cited. Mr. Milimo, for the first respondent, argued that the matter of impeachment has already been concluded in the National Assembly, and the Speaker is no longer presiding over the proceedings of impeachment. My lord, you have a decision before you, ripe, complete, concluded, that you can review. The second issue, my lord, that will be raised before you is the question of sub judice, my lord. You will be told that there is another matter pending. 3 things to say on that, my lord. Under the Mutunga rules, the rules under the Constitution on the fundamental rights of the citizens of Kenya, a citizen of Kenya can initially approach the court even on a foolscap, on a tissue paper, and subsequently augment that tissue paper with a complete petition based on circumstances as they arise. Secondly, my lord, there has been no time, and there can be no time, and the court has already noted, to file an application to amend any initial petition. And so what the parties did, when circumstances changed and an entirely new case arose, my lord, the petition before you was filed. The remedy, if any, my lord, is to stay the first petition, my lord, in view of the fresh petition that raises fresh issues that could not have been covered with that first petition and given the constraints of time. My Lord, the third thing, and this has to do slightly with the question of ripeness, are that the principles on the principle of ripeness have exceptions. My Lord, we have cited before you a case of the United States Supreme Court. This is the case of Abbott Laboratories versus Gardner. My Lord, I would call your attention with tremendous respect to the passages at page 12 and page 13 of our bundle of authorities. Pages 12, the paginating, my Lord, is at the bottom right-hand corner. Page 12 and 13. It's an important case, my Lord, because it was a case determined by the U.S. Supreme Court in 1967 and is in fact the origin of that principle in our own jurisdiction. And what the court there said, my Lord, is that where a litigant has a pressing matter that will be rendered nugatory or that must be dealt with immediately, ripeness does not apply. Examples, my Lord, and we've cited before you, when you read the submissions, there's a case called Stanislas Nyagaka Ondemu versus Kaleisoi Farmers, where you're to be jailed for contempt or to be jailed under other circumstances. It serves no purpose in justice to argue that we must wait for your jail term to become ripe before the court can help you. My learned senior, my Lord, has identified several other cases, several other circumstances, particularly in this one. But allow me, my Lord, to read the words of your brother Justice Mugambi in the ruling delivered on the 11th of October. This ruling, my Lord, is attached to the further affidavit at paragraph 38. Towards the end, I'll read very quickly, my Lord. And considering the immense public interest this matter has generated, and being the first of its kind in Kenya where the Deputy President of the Republic is being removed by process of impeachment, it is my considered opinion that this matter deserves the input of the bench so as to pronounce itself on a process that is constitutionally compliant to serve as benchmarks for future undertakings of this nature. It is necessary for the citizenry of this country to know whether the current state of law allows them adequate opportunity to participate meaningfully in the process of the removal of the Deputy President. We have also attached a court order from Kerowe, my Lord, that required the Senate to conduct public participation. My Lord, that is in my Lord? The one I've read is paragraph 38. It's a very long one. I read the last quarter of it. Yes. The ruling is paragraph 38, 39, and 40, my Lord. The ruling from Kerowe, my Lord, I refer to, which is attached to the affidavit filed this morning, had an order number 5, that the first to fifth respondents shall organize. The fifth respondent, I believe, is the Senate in that matter before Kerowe, shall organize similar public hearings closer to the citizens, at least at constituency level on each constituency in Kenya, to enable the constituents of members of parliament responsible for the impeachment process nationally to engage with and participate on hearings. The Senate is a party to that case and was one of those required to undertake public participation. When my Lord looks at the calendar produced by the Senate from pages 12 to page 14 of that supplementary affidavit, there is no room provided for public participation in violation of that court order. Let me end with this, my Lord. My colleagues from the respondents are about to astonish you and astonish Kenya with the following submission. They argue that this court has no jurisdiction even after the Senate has concluded its affairs, because in their view, Article 165, Subarticle 3C, should be read in pari materia with Article 145. They say that Article 144, which deals with removing a president and deputy for incapacity, the court has no jurisdiction. And that is true, because Article 144 says so expressly. But they say you must extend that thinking.
My Lord, can he reply after we have said?
It's before me. I'm just explaining. Well, I know they don't want me to take away their mouth, but it's a point of law. Yes. Okay. Yes. Yes. Okay.
So you are moving your application and responding to them.
Okay. I'll then await to respond to that question. I just wanted to say they make two. Yes. Oh, I see. Very good. So, my Lord, under Article 165, subarticle 3C, the court has no jurisdiction where the removal of the president is incapacity. The respondents argue in their PO and in their grounds that must be read in pari materia for Article 145. My Lord, the law is this. Unless the jurisdiction of the court is expressly denied by a statute or by the Constitution, it cannot be denied, my Lord. The authorities are on this point. But that is in contradistinction to the other argument they make. They say this court cannot now interfere until Senate has finished. But when Senate finishes, they will then come and argue the court doesn't even have jurisdiction. This is the argument, the astonishing argument being made before you. And this is an argument that 450 people in Parliament can take away the sovereign power of the people under Article 1, and they cannot answer to a court of law. This is the argument before you, which is why I say it's astonishing. They can remove the president, they can remove a deputy president, but that no one can hold them to account. That, in a sentence, is the argument the respondents are coming to make before you. And my Lord, I would urge you with tremendous respect, reject that argument on the basis of the numerous authorities this court has made before, that it is the guardian of the Constitution. My Lord, thank you very much for your time and for the privilege of your attention.